Hi, this is Rich Newsom. This is another edition of the Florida Weekly Case Law Update brought to you by the Newsom Law Firm. Thanks for joining us. This week, there's not a lot going on in terms of appellate decisions, but there is one significant decision that perhaps a lot of our audience may be interested in, and it deals with the issue of when there is a presumption of negligence for a rear-end collision. This is something that happens on a regular basis where there's a rear-end crash, and the question is when the plaintiff usually is entitled to summary judgment because someone crashed into them from the rear. This week, the first DCA gave an opinion in the case of Itiat versus Foskey, Itiat versus Foskey, Foskey. We don't have a citation yet because this just came out. But in this case, it basically involved a tow truck that was rear-ended by, in this case, another vehicle that was driven by the plaintiff. So the plaintiff was suing the tow truck for this rear-end crash. And after the case got filed, the tow truck's defense attorney filed a motion for summary judgment trying to use the presumption of negligence, trying to ask for summary judgment, basically a defense summary judgment against the plaintiff in that case. And so the court looked at the motions, and after the issues were argued, the court rendered summary judgment in favor of the defendant, in favor of the tow truck driver. So the issue before the first DCA was, in fact, whether the defense was entitled to the summary judgment using the rear-end collision. The court looked at some of the older cases, and some of the cases that they relied upon was the Clampett versus DJ Spencer Sales case. That's 786 Southern 2nd, 570 is a Florida Supreme Court decision from 2001, and another fourth DCA opinion from 85, which is the Tozier versus Jarvis case. And the court gave a real nice articulated decision about what factors should be considered when trying to decide whether there should be summary judgment in one of these rear-end crash cases. And the court basically said there's three factors that need to be looked at in terms of the factual issues. First, whether there was an abrupt or arbitrary stop in place where a lane change would not reasonably be expected. Or second, whether there was a sudden brake failure that caused the collision. And third, whether the lead vehicle was illegally and unexpectedly stopped. So in this case, the court looked at those three factors and said, you know what, we think summary judgment was improper. We think that there was sufficient evidence. In this case, the court said that the defense was not entitled to summary judgment because there was some facts basically showing that in this case, the defense had to deal with some evidence that basically the tow truck driver had illegally changed lanes. And so because there was some evidence in that, the court found that summary judgment was improper because the plaintiff, the person who caused the rear-end crash or who ran into the defendant, the plaintiff had shown some evidence and that was an issue for the jury. So this is a good case where the court gave a nice, clear articulation of what the rule is, what kind of factors should be considered in these kinds of summary judgment. So other than that, there wasn't a lot happening this week. We will, of course, report back again next week for more cases. And we thank you for joining. We hope this is helpful. We'll have some of the citations on our website, newsomlaw.com. And we hope you join us next week for another edition of the Florida Weekly Case Law Update. Thanks again, and see you next time.